This is the third of 6 lectures on constitutional law. 4, thank you. Somebody's paying attention. Some people are awake too. And thank you so much for coming. You know, the last 3 of these we've had over 50 people, and I haven't done a head count, but it seems like it might be similar. And you know, I wasn't really sure how many people would want to come to lectures on constitutional law on a Thursday afternoon when, you know, well, at least it's raining, so there's not really anything better to do. So I really appreciate it. The idea here is to provide a structure for thinking about constitutional law issues, and not to get into the specifics of, you know, a particular part of the Constitution, either the state or the federal, but to talk about the overall structure, the framework, the way that it creates a set of rules that govern our government and govern ourselves as well. And to then have that framework to be able to go forward and look at specific issues, whether current or past issues, in order to be able to understand them better within the framework that the courts, for the most part, have created for our legal system. So that's the overall goal. My name is Lindsay Showman-Warren, and I'm an attorney in town. I work on constitutional law issues, often concerning the power of local government and state government relative to federal government and people's rights and corporate rights and all that stuff. So we started back in March with an overview of the structure of government, looking at separation of powers, both between the branches of government and also between the federal and the state and local governments. And then in the second lecture, we looked at the judicial branch of government, which has a special role because when the legislative branch, like federally Congress or here the state legislature, when the legislative branch steps outside of its realm of power, or when the executive branch steps outside its realm of power, the judicial branch says, whoa, you can't do that, you don't have the power to do that. But when the judicial branch steps outside its realm of power, it has to police itself. So that leaves the judicial branch of the government, whether it's the state Supreme Court or the federal Supreme Court, saying, do we have the power to address this issue? Do we have the power to hear this case? What is the scope of our own authority as one of the separate branches of government? So that's why we focused on the judicial branch in the second lecture. In the third lecture, we looked at the relationship between federal, state, and to some extent local as well, government, so that vertical federalism, as courts and legal academics like to call it, and looked at how that plays out when federal law and state law interact, when, for example, they say different things about a particular topic, which one trumps the other, and that sort of thing. So that was the third lecture, and then we took a break. I had some oral arguments, and there was some scheduling stuff here, and some other things, and so now we're back, and we're meeting today, and then next Thursday, and then the following Thursday, and that's going to be the end of this 6-part series. So just a little housekeeping for folks. Reminder, cell phones, if you could turn them off. Bathrooms are through the hall. We're not going to take a break. We're going for an hour and a half, so please just get up and use the bathroom if you need it. I want to really thank the people who've been working behind the scenes to make this happen, doing advertising, setting up a space, editing the videos of these presentations so that people can go on to Peninsula Area Public Access Television and watch them, or go on the internet and watch them as well. And that's Rachel Ringer, and Casey Williams, and Dale Knudsen. So thanks to the 3 of you for persisting on. So I am happy to take questions as we go, particularly if you're like, hey, wait a second, I'm a little confused on how this rabbit hole is meandering. You know, please go ahead and raise questions. But at the same time, I'd like to reserve the right to say, you know, hey, I think we'll get to that later. So if I don't get to that by this point, please ask again. So if it's okay to delay your question, I might do that. Also, we're talking about some really complex stuff, and if I'm not really up on that particular area of the law, if I haven't researched it, I'd like to be able to say, I don't know. And so I might pull that I don't know card as well. So I'll try to be honest with answering questions, and that might mean that I don't have the answer based on just having researched it or not. One thing about being an attorney is I know how to research. I don't necessarily know what the answer is going to be. So if it's something that I'm not familiar with, I want to be able to say, hey, I don't know that. So feel free to ask questions as we go, and we'll see how much time we have at the end. So this lecture today is going to be transitioning from the first three, which was more or less about the structure of government. Who has power to do what? Both between the different branches of government and then between the federal, state, and local governments. So the first three lectures were about that. Today, next week, and the following week, we're going to be looking at the rights that people have within the constitutions. So today is going to be focused on the rights protections in state and federal constitutions. We're looking at the framework of it. Whose rights are protected? What are they protected from? What does that mean? And kind of how does that framework apply? How do the courts think about, whether somebody's rights were violated or not? The lecture next week is going to be about privacy and protesting, so kind of a specific topic within the rights framework. And if you want, on your way out, there's a handout that relates to that on protecting your rights in kind of immigration, law enforcement contexts. So somebody brought that in, thank you for bringing that in, and it's on the back table. So feel free to grab a copy of that on your way out, probably a little sneak preview to some of the stuff we're going to be talking about next week. And then the following lecture on May 4th will be about corporations as rights-bearing entities. So how did corporations get rights under the US Constitution and to a lesser extent under the state constitution? So we'll look at that framework as people are curious about how that happened. So one of the things we talked about at the very beginning was why we have government and what government comes from, what it's for. This idea in the Declaration of Independence is that we have government to protect our health, our safety, our peace, our happiness, our rights, and to provide that consent of the governed. One problem that people debated at that time, at the end of the 18th century, and even into today, is who is that body of government? Whose consent matters? Who is the body politic that has rights, that gets protected by the constitutional framework of government? So that's where we're going to start, because we can say, well, I have a right, but does the government recognize me as someone who has rights within the framework of the constitutions that we live under? So we talk about the Bill of Rights, which is the federal constitution's amendments 1 through 10, and they're the amendments to the Constitution. So states at the time had created their own constitutions. Most of the state constitutions put the Bill of Rights or Declaration of Rights, which is what it was called in Washington's Constitution, as the first article, as the beginning of the Constitution. It starts with, hey, people are created independent and free, and they have the power to constitute their government and all the political powers inherent in the people, those sorts of things. That's how most of the constitutions start out. The federal constitution, though, starts with articles that have to do with what power the federal government has. And then the Bill of Rights, the rights protections, came in 2 years later in 1791 as amendments to the Constitution. So what was going on there? Like, why didn't the federal government why did the federal Constitution start with rights protections just like the states did? And there's kind of two theories that constitutional law academics will talk about. One is the idea within the debate at the Pennsylvania Constitutional Convention that, well, the states have all this power, and the federal government is a government of limited power, right? Congress can only do the things that it has enumerated powers to do in Article 1 of the US Constitution, or necessary and proper to do those enumerated powers. So if Congress only has those limited powers, then we don't really need to confine the federal government's, the scope of the federal government's authority by saying, well, there's these other limitations, like government cannot limit people's speech or assembly or petition for redress of grievances and that sort of thing, right? So that was one of the theories, was, well, we don't need it. We don't need a Bill of Rights in the federal Constitution. And a lot of people said, no way, we don't agree with that. And there was kind of a gentleman's agreement to add amendments to the Constitution after it was ratified, and that was some of the first things that were done. So that's where the US Constitution came into effect in 1789, and then 2 years later we had the Bill of Rights come in. So they're amendments to the Constitution, as opposed to our state constitution as an example, or most other state constitutions where they start with the people's rights. And that has to do with this idea that federal government is limited. But a lot of people, even then in the 18th century, said, we don't believe this federal government is limited thing. We think we need to express and protect our rights. And then there was another concern, which was, well, if we only enumerate certain rights, what about all the other rights that people have? If we only write down, rights 1 through 10, and we forget right 11, then won't that mean that, that right will kind of disappear? So there was this concern about documenting the rights and forgetting to name certain rights and what that might lead to later on. So we have things like the 9th Amendment to the US Constitution that say, well, the rights not enumerated herein still apply, but the history of that is now debatable, and academics will be like, well, there's these rights that people had that they meant within the 9th Amendment, but the courts say, oh, no, that's not included in the 9th Amendment. So there was this discussion about, well, what's the effect of naming certain rights and then not naming other rights, and how would that play out? So that was another argument. I don't know how much it's kind of a post hoc argument for why the Bill of Rights wasn't there front and center in the US Constitution when it was initially ratified by the people of the states. Also, there was the issue of who gets rights. Who is part of that body politic? So I wanted to start with that at the beginning of this talk today. So on the handout, which is Constitutional Law Lecture 4, Rights, Protections of State and Federal Constitutions. For people watching this video later, you can find this online at tinyurl.com/Constitution Lecture 4, like the number 4. And that's a link to this handout. Hopefully it's still live by the time you see this. So the Virginia Declaration of Rights, 1776, this was the heart of the American Revolution, and these crown corporations were pulling away from British control and saying that they were now republican states, they were now sovereign states, and they were their own governments. Thank you, King George. We'll be seeing you later. And the people the Virginia legislature said, okay, let's name the Declaration of Rights that people have in Virginia. And they started with Section 1, that all men are by nature equally free and independent and have certain inherent rights, of which, when they enter into a state of society, I italicize that and we'll return to that, but think about what that means. They cannot, by any compact, deprive or divest their posterity, namely the enjoyment of life and liberty, with the means of acquiring and possessing property, and pursuing and obtaining happiness and safety. So that's very familiar. That's like the Declaration of Independence. This is this idea that people come together in this social compact and form government in order to protect their rights, their life, liberty, their property, their happiness, all of that good stuff. So the legislature, though, was concerned that this could get interpreted in a way that applies to people that the legislature didn't want to have rights. And so they made sure that they added this italicized phrase, which I italicized, when they enter into a state of society. So they're talking about enslaved people in Virginia and saying rights apply to a certain body of people, but not everyone. So slaves expressly don't get that because they are not in a state of society. So there's been this issue of who gets rights and who doesn't get rights.
Were women in a state of society?
So women are a little more complex. legally speaking, because unmarried women or widowed women kind of threw the whole concept of who's a legal person into disarray. So let's just start with like this, like who's a legal person? And in our legal framework, you're kind of, you or a thing is kind of either a person or property. So if you're a person at the basic level, you can own property, you can contract with others, you can sue, and you can be sued. That's kind of at a basic level. And then we add all this other stuff of what it means to be a person, like, hey, you've got rights too. Like maybe the right to sue, the right to own property, the right to contract, some other rights, getting into that. But at a basic level, it's property, contracts, sue, and be sued. So that's what it means to be a legal person. To be property means you can't do those things. You can't own property with your property. You can't contract with others. You can't sue and be sued. You're a thing. You're not a person. And so person is not the same as people. But person is usually used in this legal sense. Sometimes in different statutes you'll see it defined as to what person means. Person means any natural person, which is usually synonymous with human beings. And then, maybe like all business entities or corporations, partnerships. The legislature will define what a person is for purposes of different statutes. So if we're talking about people who were considered to be slaves, they were property. They were clearly property. They had no rights. They couldn't own property. They couldn't contract. They couldn't sue and be sued. You would sue the slave's master if you were wronged by the slave. It would be like if somebody's horse kicked you, you wouldn't sue the horse. You would sue the owner of the horse. So that's what it meant to be property. So women were supposed to be property, but many of them were like, I don't have a master, right? Like either my master died, as in they're a widow, or they're adults, emancipated, so to speak, from their father, and they didn't get another master, meaning a husband, right? So what does society do with those women? In theory, they're supposed to be property, which means they can't own their own property, they can't contract, they can't sue or be sued, but yet functionally, they're human beings walking around like everyone else, and like they need to, exchange goods for services and have a place to live. And if they're wronged or they get wronged, like shouldn't they have recourse to the legal system? So like women were kind of bending the rules for a long time, so it's not clear cut. So that's one of the reasons why I'm focusing here on African Americans, Black people who were enslaved and who also became free, and because legally, in the history of the United States, that was much more of a clear situation of property versus person, where women kind of blended it, and it's a longer, more complex story. So for purposes of us just talking in this framework, I picked this example, not necessarily because it's more important, but because it's somewhat simpler in a legal framework. Because, as we know, after the Civil War, Black people throughout the United States went from being, property to being persons. Although the story is much more complex than that, it's not as complex as the story of women within the legal system. Is that okay?
And isn't that similar to other minorities too, like Native Americans or Asian Americans or lots of people who didn't necessarily have rights, but they also were entering contracts and owning property, but they weren't considered citizens either, right?
Yeah, so the same is true for other groups of people of color. So Native Americans.
They weren't property.
For people of Asian descent, in many cases, the courts set up rules to prevent people from accessing the courts, to prevent people from accessing property, to prevent people from being able to contract. In this sense, when we look at U.S. history, the law is a weapon to disenfranchise people of color and strip them of things that they had or their ability to defend themselves from others. For a long period of time, Chinese Americans could not testify in court. So basically, if a white person killed a Chinese American person and the only witnesses were other people who were Chinese American, the white person was just going to walk away free with impunity. So the courts set up rules to prevent people from accessing the courts or to prevent people from being able to retain things that were theirs because they didn't have a right to own property, all sorts of stuff. So yeah, there's a book for the Native American history by Walter Eco Hawk, I think is the name, called In the Courts of the Conqueror. And I'm not thinking of a good reference right offhand for Asian Americans in the United States.
I can remember in older documents, unmarried adult women being referred to sometimes as emancipated woman or femme sole.
What was the last? So unmarried, femme sole, yeah. So unmarried women being referred to as emancipated women or femme sole. Yeah, I mean, we'll see that language if you look in older law books. Employer-employee relationships are referred to as master and servant. There's sections in the books for, there's a whole section in legal reference books called children of unmarried parents, which used to probably be one word, just and so, I mean, this whole history of who's part of the community, who's got rights, that is a big debate, and it still is a debate in the United States. So, in the beginning, 1776, the legislature of Virginia is saying, we gotta make sure that there's no way people can construe this Declaration of Rights, this democratic power of the people, all political power inherent in people, to apply to enslaved people, to apply to slaves. That, of course, was a raging debate, 1776, and on into the 19th century. And the struggle for emancipation, the abolitionist movement, all was scaling up into the 1850s. And in that process, a number of enslaved people were trying to use the courts to get free. So often these are called freedom suits, and people would be in a free state and say, hey, I'm in a free state, I shouldn't be a slave. And the courts went kind of back and forth on that for a while in different ways. And one case, Dred Scott versus Sanford, which is on the handout here, went up to the U.S. Supreme Court. And the U.S. Supreme Court, with Chief Justice Taney, writing a 50-page opinion, was trying to end this debate. And he tried to end the debate in a way that, many people might say precipitated the crisis of the Civil War. This original intent of the United States was never to give black people citizenship at all, no matter where they were. So let's read it. So section 1B, Dred Scott versus Sanford. I pulled out a little quote there because it kind of epitomizes the tone of this opinion. Black people had no rights which the white man was bound to respect. So this became law in the United States in 1857. So Chief Justice Taney wrote, "The question before us is whether the class of persons described in the plea in abatement, that class being black people, both enslaved and free," so all black people in the United States, whether property or person, "compose a portion of this people." And he's referring there to the people of the United States, right? Who's the body politic? Who are the people whose rights matter, who get rights, who are part of the government? So do black people compose a portion of the people? And are constituent members of the sovereignty. We think they are not, and that they are not included and were not intended to be included under the word citizen in the Constitution, and can therefore claim none of the rights and privileges which the instrument provides for and secure to citizens of the United States. So Chief Justice Taney tried to end the free state, slave state debate by saying, you know what? Black people were never supposed to be citizens. So that led to a lot of concern, particularly in the North, not necessarily in the South, because it was like, hey, great. If you look at Abraham Lincoln's House Divided speech in 1858, he talks specifically about Dred Scott and says, how can we exist in this place where half the states, black people are considered free persons, and then the other half are considered property, right? Because how does somebody go from being property in one state to then becoming a person in another state and going back? There was another case, Lemon, where I think a North Carolina family with slaves was traveling to New Orleans, and at that time they went up to New York to then get a steamship direct to New Orleans. And in New Orleans, one of their slaves said, hey, I'm free. I'm in New York. The free air of New York cannot have me as a slave. And that case was going up. And that was the sort of case that Lincoln was talking about in the House Divided speech of what's going to happen in New York when somebody who's considered property, when the U.S. Supreme Court, Chief Justice Taney at the helm, says, hey, this person in New York is still property, is not a person. What is that going to mean for New York as a free state? Because wouldn't that mean that somebody could basically bring slaves to New York and be a slave owner in New York, residing in New York? Right? So that was this crisis, this House Divided. And when we study this issue in law, I was really lucky to have a professor whose expertise area was the history of slavery. We basically skipped the next 5 years because the law kind of just skips the next 5 years because it wasn't a legal debate anymore, it became a military debate. So after that then was a period of Reconstruction where the North basically imposed martial law on the South and tried to enforce the emancipation of slavery on a society that was built with slavery as a key component of it. slaves constituted about half of the wealth of the southern states. So imagine if somebody came in and said, we're going to take away half of your wealth. Right? I mean, that's a big economic impact on people, right? And so there was a huge debate, obviously, and a massive war over that. So the first of the three Civil War amendments, so these are U.S. constitutional amendments that went into effect after the Civil War, was Article 13, which was basically that slavery and involuntary servitude shall not exist in the United States. The second one was trying to address some more of the nuanced problems, and that one's the 14th Amendment. So I want to get to that, but first your question.
I'm sorry, I want to go back to the Dred Scott decision. Be sure I understand this correctly. I know that during the Civil War, there were about 250,000 free blacks in the South, and quite a few in the North. So this Dred Scott decision was saying it doesn't matter whether you're a slave or not if you're black.
Mm-hmm.
Now, how did that cover other people in the country at that time who were considered necessarily white, maybe Asians, Native Americans, and I think they referred to people, Muslims, as Mohammedans, but were they considered, they weren't slaves?
So the question is, how did Dred Scott affect people other than black people in the United States? I don't know the nuances of that. I'd have to research it. But the implication ultimately is who gets to be a citizen. And my guess would be that whether people of color other than black people were considered citizens at all at that point, is that it would be a pretty negative situation there. But I'd have to research the nuances of it.
Wasn't it also Irish and Irish?
So
And
is it also
Italians?
Irish? Yeah, there's a whole...
Italians, Irish, I think.
There's a book on that too, how the Irish became white.
Yeah.
Because Irish people in the United States in the 19th century were not considered white. So yeah, a scholar has written a book, How the Irish Became White. So another question.
Well, I don't know the answer to this question. If a slave owner killed a slave, could he be convicted of murder or anything like that?
So the question was, if a slave owner killed a slave, could he be convicted of murder? I believe it depended on the particular state and what the laws were in the particular state. There's a case from North Carolina, State versus Mann, that looks at a slave being shot by somebody who was renting the slave, and basically it's a pretty hard read. So, 1868, we're kind of done with the Civil War. The North is trying to reconstruct the South without slavery. And the U.S. government institutes the 14th Amendment at that point, so amends the U.S. Constitution. And the 14th Amendment really forms such a critical part of the framework of constitutional law in the United States. It is like this cornerstone amendment. It has such a big role. So really what we're going to be talking about for the rest of today is the 14th Amendment. So the reason for that is that it includes this equal protection clause. It also includes the due process clause. And due process is such a nebulous concept that it becomes flexible or inflexible. It can mean a lot of different things in a lot of different circumstances. And this is an area where the rights that we enjoy today, many of them come from due process under the 14th Amendment. So just an example is that initially the Bill of Rights in the US Constitution only applied to protect people from actions of the federal government. The court said, well, this is the Bill of Rights that restricts the actions of the federal government, If people want protection from the state government, they need to turn to their state constitutions, where there is a Bill of Rights or Declaration of Rights in the state constitutions, and that's the restriction of the state government. So people tried to use, in the 1830s, for example, the federal Bill of Rights to protect themselves from actions of the state government, and the US Supreme Court said, fairly logically, well, no, that's really just a restriction on the federal government. Through the 14th Amendment and the Due Process Clause of the 14th Amendment, we now get the federal Bill of Rights to protect us from actions of state and local governments. And the courts have basically said that, well, due process, this due process right, is kind of like one of the basic rights. I mean, they don't quite use the language of human rights, but that's almost it. Like, what's like the foundational minimum rights that people have? And the courts have said that the Bill of Rights is incorporated. If you want to look it up, that's like the legal academic word, is an incorporation of the Bill of Rights to apply against the state and local governments. It's done through the Due Process Clause of the 14th Amendment. So that clause, it's really short, but it's foundational to constitutional law today. So we're looking at the 14th Amendment. The 14th Amendment starts with Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens in the United States and the state wherein they reside. So how do you overturn a U.S. Supreme Court decision? That's directly overturning Dred Scott. Dred Scott said black people aren't citizens. Right? The 14th Amendment made that clear. No, all people born or naturalized in the United States are citizens of the United States. And incidentally, this is kind of where the concept of U.S. citizenship came in. There were elements of it before, but people often thought of themselves as citizens of particular states. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny any person within the jurisdiction the equal protection of the laws. So this language sounded very broad. Women at the time said, hey, we think this applies to us too. Right? Many people looked at this and said, this is incredibly broad language about leveling the playing field and bringing everybody into that state of society that was so emphatically denied to many people less than 100 years previously. The U.S. Supreme Court, though, made it pretty clear that no, that doesn't really mean what you think it means. And the case, I didn't put it on the handout, I'm sorry, is the Slaughterhouse case. And the Slaughterhouse case, kind of appropriately named, said that privileges and immunities of citizens of the United States, that clause doesn't really mean much of anything. It definitely doesn't mean that women have the right to vote, for example. And so just ignore that that's there. And within 5 years of enacting the 14th Amendment, one of the key provisions of it was basically nullified by the U.S. Supreme Court and has only barely come back in the intervening 150 years or so. Another incidental issue before we move on from the 14th Amendment is this question, well, who has rights? Remember that Article 5 of the U.S. Constitution, the 5th Amendment of the U.S. Constitution includes a taking clause, which means that the U.S. government shall not take somebody's property without just compensation. This comes in eminent domain issues, where like the government wants to build a canal or build a road and take somebody's property. Well, the government has an obligation, it's a right to be compensated fairly for that. Well, the government had just taken everyone's slaves, which were property, right? So there were actually cases and there were payments to slave owners for emancipation because they argued and the courts agreed that that was a takings, that the government was taking people's property by turning enslaved people from property into persons. So to stop that, In Amendment 14 to the U.S. Constitution, Section 4 includes, and I've excerpted it a little bit, but neither the United States nor any state shall assume or pay any claim for the loss or emancipation of any slave, but all such debts, obligations, and claims shall be held illegal and void. In other words, technically it's a taking, but we're saying expressly emancipation is not a taking. And they have to say it expressly in the U.S. Constitution. So when we're talking about taking something, whether human beings or things, I mean, we deal with this with rights of nature, the idea that the earth has rights. When taking something from property to person, we're going into the deep structure of the U.S. Constitution. Because some people have rights to hold on to property, even when we look back 150 years later and say, that is a person, not property. That's a human being, not property. But at the time, I mean, this is how deep it goes. Those people were property. I think an example that's worth thinking about is the people in Texas were upset that Mexico was violating their rights. You know, at one point Texas was part of Mexico, and the government of Mexico had abolished slavery, I think in the 1820s or so. I might have that wrong. And so now the people in Texas, their rights were being violated. Their right to own slaves was being violated by the Mexican government, and they succeeded for Mexico, asked the United States to join the state of Texas, and then decided to join the United States. So, you know, who has a right and who is property has been a struggle in the United States. And if you look at like minors, you know, they have some rights, but they're also still property. It's still an ongoing issue with how we classify people within that framework. Yes?
So since we're talking about women's rights, was the 14th a departure in terms of institutionalizing those rights for women of ownership, or were they allowed to own prior to that? Because in England they couldn't own property.
So the question goes back to women and owning property, and did the 14th Amendment address that? I would have to look at the history to be able to answer that with any specificity. So I'm sorry, I'm going to give a pass. If I can pass it now.
So prior to the 14th, did citizens have the right to due process, or was that a new concept as part of the 14th?
There was a due process clause in the 5th Amendment, and there was, wait, am I getting that right? I'm totally blanking right now. I'd have to double check.
But there was a due process before that.
Well, the idea of due process really is kind of a natural law concept. And so what we're going to get to next is kind of how the courts struggled with that. So maybe let me pause on that question, and maybe I'm going to pass on it, but I think we're going to get to it on the second part.
Are you going to explain what due process means? I don't know. I don't quite know what that means.
Yeah, let me do that. So due process is two parts. There's procedural due process, which is, you know, when you go to court, you have a right to be heard in court. You have a right to procedural due process. You can't just be told, hey, you've been judged to owe somebody money, or you've been judged to be a criminal without actually being there. So that's just procedural due process. And then there's substantive due process. And substantive due process refers to rights that people have that the courts say are part of that life, liberty, and property. So in the 14th Amendment, nor shall any state deprive any person of life, liberty, or property without due process of law. And so that's really this question that is left to the courts to a large extent of, well, what is life, liberty, or property? It's pretty open-ended. So one thing that the courts did at the end of the 19th century, beginning of the 20th century, when states and local governments were passing a lot of labor laws ideas like minimum wage, like 40-hour work weeks, like child labor laws, like health and safety laws in the workplace, the U.S. Supreme Court said, wait a second, people have a right to liberty, and that liberty interest includes the right to choose how to contract with somebody. So if I'm looking for work and you're a potential employer, I should be able to choose, I should be able to have the liberty and the freedom, right? It's there in the Constitution, right? The life, liberty, and property. I should have that liberty interest in choosing how I contract with you. So if I want to work for you for 10 cents a day, that's my freedom, that's my liberty interest in doing that. If I want to work for you in unsafe working conditions, I can do that. Excuse me. And the U.S. Supreme Court said, yeah, that's part of this life, liberty, and property due process right of people. They called it liberty of contract or freedom of contract. And it was the law in the United States from the beginning of the 20th century until about 1937. And that was known as the Lochner era, after the case Lochner versus New York, which is one of the U.S. Supreme Court cases really entrenching this idea of liberty of contract. So that's an idea from substantive due process. So we talked about procedural due process, the process, and this is substantive due process. What does it actually mean to have life, liberty, or property? Well, today, the courts, judges, justices look back on the Lochner era and say, oh, that was a really bad idea, because we took this concept of due process and we basically applied our own theory of what the law should be, and we did it in a constitutional way, right? It's there in the 14th Amendment. So, Congress can't violate the 14th Amendment. I mean, so it's there above the reach of legislative governments, whether state or federal. And that liberty of contract idea basically prevented the expansion of labor laws for about 30 years. It was a substantive due process right. So the courts said, or today the courts say, that was a bad idea. That when the people want to expand their rights, they need to do it themselves. Right, let's go back to who the court is. The federal judges are appointed by the president and ratified by Congress and the Senate. At the state level, we elect them, but how many of us really kind of know the positions of a judge when we vote for the Supreme Court justices for Washington State? I mean, it's pretty remote from what we think of as being able to engage in the political process. So the courts call themselves the least democratic branch, right? The legislative branch, we elect a bunch of people and they try and figure out a budget for the state. We'll see if that happens. And then, the governor, the president, we get to vote on them. At the federal level, we don't get to vote on judges. And so the courts call themselves the least democratic branch and say when it comes to what people's rights are, who are we to say due process, oh, that means no labor laws, period. Because all those violate people's liberty of contract. So the courts now are often very reticent to expand the idea of due process. So I'm still trying to answer that question of what does due process mean? And unfortunately, it's a very complex answer. Casey asked me to make a glossary, and I apologize I didn't get that done in time for this lecture. I'll try to remember to put due process on there and see what Black's Law Dictionary says for due process. I have a feeling it might be a long definition. So we're going to skip section 2 for now and come back to that and go to section 3 on the back of the handout, the framework for analyzing rights under due process and equal protection. So most of the time, let's see, let me back up a step. So when we talk about a right, who does that right protect us from? Maybe I can't skip section 2. I don't think I can. Let's go back. There's a reason for this one. So section 2, the state action doctrine. So there was this question pretty immediately after Amendment 14 and the other Civil War amendments of, well, who gets limited by a rights protection? So who cannot deny somebody equal protection of laws? And the U.S. Supreme Court said, you know, that 14th Amendment, when we look at it, it says that it's actions by the state. In other words, it's actions by the federal, state, or local government. So when we say state action, we mean government action. And that's really who gets limited. So when we say no depriving people of life, liberty, or property without due process, or no denying people within jurisdictions of equal protection of the laws, well, those limitations, because one person's right is a limitation on someone else's behavior, those are limitations on the government's behavior. Those aren't limitations on private person's behavior. So that was the civil rights case, section 2A on the handout. And the court said in 1883, it is state action of a particular character that is prohibited by the 14th Amendment. Individual invasion of individual rights is not the subject matter of the amendment. So, and a hotel decides to discriminate against people on the basis of race. Well, the 14th Amendment doesn't address that. Congress can pass laws and states can pass laws, and both have done so in order to prevent that kind of discrimination. But the courts have said that private violations of due process or equal protection are not within the scope of the 14th Amendment. So when I think about the civil rights acts that have been passed by Congress, starting with the Reconstruction era, we also know 1964 Civil Rights Act. Those are acts of Congress that prohibit certain kinds of discrimination. And that's why that kind of discrimination is illegal. But it's not because of the 14th Amendment. So the courts have said, and continue to say, that there's this threshold to applying the 14th Amendment, which is that it's about state action, government action. So remember that the 14th Amendment is what incorporates the Bill of Rights to apply to actions by the state. So for example, if I prevent somebody from speaking their mind, I'm not violating that person's First Amendment rights because I'm not the government. If the state of Washington does the same thing, it might be violating somebody's freedom of speech, their First Amendment rights, because it is the government, but that private contact. So a kid in school can't say, teacher, you're violating my First Amendment rights. Well, I'm sorry, I picked a school example. That's fast. I mean, in this context, individual with individuals, we're not talking about we're not talking about constitutional rights violations because there's not that state actor, that government actor.
So a state-run campus, due process and freedom of speech, the student movements of the 60s were basically right in saying you can't mess with our freedom of speech, we do need due process if you're going to connect. A campus, a state-run college or university, would be under the state government.
Is a state actor. Yeah. A private college is not a state actor. Now there are some exceptions to the state actor doctrine. So for example, a private prison is performing a function that we don't normally let private people do, right? Like, I can't just open a prison and enslave people. And so if a private party is taking on a government function, then we say, well, you become a state actor. or if a private party has meshed themselves with the state to a certain extent, then the courts say, well, you become a state actor. So there are exceptions to it where a private person can become a state actor. But generally, the state action threshold is a key part of most constitutional rights. So not only do we have to look at, well, who gets rights, but also what do rights protect you from, or whom do rights protect you from? They protect you from the government, not from other private persons. When we're talking about constitutional rights, there are certainly state law and federal law. At the state level, the Washington law against discrimination, at the federal law, numerous civil rights laws that protect you from private discrimination. But those aren't constitutional rights in the sense that they don't come from the 14th Amendment or most other constitutional amendments. Yes?
I'm just curious about how one is deprived of life and how the courts have dealt with it. All I can think of is things like Road Canal or the pipeline, things like that, where people might be deprived of life. How do you deal with it?
So I think the death penalty would be an example.
And then, besides physically taking life, how about the environmental things that might cause life?
I don't know if the courts have considered that to be a loss of life issue. I'd have to research that, so I'm gonna pass the details there. Sorry. Yeah.
So, public schools are considered an agent of the state. So, they apply its government there. Whereas private schools, they wouldn't. And same with private colleges. But in many cases in this country, public schools have contracted out to private businesses to run their schools. Now I wonder there whether the federal law, the 14th Amendment, would come into effect if it's really still a public school or a private school.
Yeah, so the question was, well, when a public school contracts out services to private entities, do those private entities become state actors? Are they bound by the limitations that constitutional rights place on government, or are they private? It's one of those questions that we have to look at the case law and see how the courts have come down. Yeah, because it's this area of, well, are they entangled? Have they taken on a government function? Do they fit into one of these other exemptions from the rule that constitutional rights protect us from the government, not from other private parties?
There's a case in the news this week about I think it's the legislature in Alabama has passed a law that enables a large church, like 8,000 parishioners, to employ their own private police force, meaning they have policing powers that are generally attributed to government bodies. So I would guess that this is a question of what powers and what responsibilities go into that private police force, not a guard, not a security force. I think the ACLU said they're going to challenge it on the basis of this is involving a proper government function, the private body, and it's not appropriate.
Yeah, so there's probably a case study that's right on point for this issue, which is in Alabama, churches employing private police force, not just security guards, but police. And is that becoming a state actor or not? I think that's an example directly on point for this issue. And I don't know what the answer would be specifically. It's going to end up being very fact dependent. And that's where the courts have come. It's like, it's a pretty nuanced rule. But the big thing to take away, I mean, I'm going to kind of move us along because we need to in the interest of time. The thing to take away here is that constitutional rights don't protect us from each other, they protect us from the government or entities performing a government function or mesh with the government. But those are the exceptions. There are some rights, though, that protect us no matter what. And so there's an example, the U.S. Constitution, Amendment 13, passed in 1865, that says, neither slavery nor involuntary servitude, except as punishment for crime, shall exist within the United States. So that's one that the courts have said, you know, that applies not just to protect us from the government, but it also protects us from private parties. Neither slavery nor involuntary servitude shall exist within the United States, right? So it's not just a protection from the government's violation of our rights to not be slaves or involuntary servants. You know, the irony with that, and I think there's a recent film that hits on this issue directly called 13. And who's seen that? Who's seen 13? 13? It's about the 13th Amendment to the United States, and specifically this clause, except as punishment for crime, right? Which is a giant loophole from the requirement that slavery does not exist within the United States, except as punishment for crime. So essentially there's no private slavery anymore, but if somebody's been convicted, the state can enslave them, right? And that exception is there. So we need to not say that we abolished slavery in 1865, rather we abolished slavery except as punishment for a crime. So there's also exceptions in state constitutions. Remember, it's not just the Federal Bill of Rights, but also states that have constitutional protections for people. And there's a case from New York on the top of the backside of the handout called Sharrock. And in that case, the New York Court of Appeals, which is the Supreme Court in New York, said, you know, in contrast to the Due Process Clause of the 14th Amendment, which is phrased in terms of state deprivation of life, liberty, or property, Section 6 of Article 1 of the New York Constitution guarantees that no person shall be deprived of life, liberty, or property without due process of law. So it's a little bit like the phrase in the 13th Amendment, shall exist within the United States. So no person shall be deprived of life, liberty, or property without due process of law. That's what the New York Constitution says. So the highest court in New York said, conspicuously absent from the state constitution is any language requiring state action before an individual may find refuge in its protections. So in New York, based on this case, the state Supreme Court has said, yeah, normally, if you're applying the federal due process clause in the 14th Amendment, there's a state action threshold. In order to use that constitutional right, you need to prove that the person you're using it against is the government or a state actor. But in New York, to use the New York state constitution's due process clause, the state Supreme Court there has said there is no state actor requirement. That due process clause, that protection of life, liberty, and property, protects you from anyone, right? So this state action threshold is something that the courts have set up, right? The courts have said, well, we interpret the U.S. Constitution in this way to require state action. Meanwhile, the state of New York, the highest court there, has said, we interpret our state constitution to not have a state action requirement. And the courts have said that that sort of interpretation is the province of the state courts. So just because the federal due process clause has a state actor component and the state of New York's due process clause does not have a state actor component, doesn't mean they're in conflict, so they're not preempted. Rather, that state constitution can be more protective than the federal constitution. So in New York, your due process clause rights are more protective than your 14th Amendment rights because you don't have to prove that the person you're asserting your rights against is somebody who is a state actor. In Washington state, I picked an example from Washington. It's not as clear-cut as the one from New York, but in a 1999 case, and that's citing an earlier case called, so this one's Wehrmark versus Progressive Campaigns, the court said that citizens may enter commercial property, which is the functional equivalent of a public forum, in order to engage in initiative petitioning. So when we're asserting our right of initiative, which is in the state constitution, we have the right to enter commercial property, which is the functional equivalent of a public forum. What that means exactly is, court interpretation based on the facts, but it's an area where our state constitution has said there is no state actor component here, at least not expressly, and we're deviating from what the federal government says about where people can petition. Because the federal government said, it's a private mall. Sorry, a private mall is not a state actor. So you can't just, do your political activity in a private mall, even though it seems to be like kind of the new town square, and that used to be where people would go to do their political activity. But the mall, it's private, sorry, state actor, you can't do it. It's not a state actor, you can't do it.
Just an observation, prominently in the front door of its local Safeway on Lincoln is a sign banning initiatives.
Right, so the Safeway on Lincoln has put up a sign saying no initiative signature gathering here. This is one of the cases where Mark versus Progressive campaigns that Safeway's lawyers have looked at, I hope, and said, okay, we think we can ban initiatives here. Because Safeway's argument is going to be, because our commercial property, right, is not the functional equivalent of a public forum. That's going to be their argument.
I think that has been the exception at different venues. If you can demonstrate that there is some element of public service performed or demonstrated on those premises, then they have to allow you to participate by petition if you want.
Right, so the statement was, well, what if there's other public services performed at that site? Then how could that private property ban certain activities like petitioning, but allow others? So, my question would be, next December, is somebody out there ringing a bell to collect change from the Salvation Army? And get a photo of that. And when Safeway says, sorry, you can't signature gather here for an initiative, send that photo into Safeway's legal department and see what they say. Yeah. Because Washington doesn't have an express state actor component for its initiative clause. Yeah. And Safeway is playing with this, and saying, well, can they find that they're not a commercial property, or maybe they're hoping that the state Supreme Court will have changed its opinion on that by the time we get up there, and well, not me, I'm not involved in that. Yeah, so yeah, Girl Scout cookies. Is Safeway going to start discriminating on who can do activities that are the equivalent of a public forum at Safeway stores? And if they want to stand by that line, based on where marked, they need to say, sorry, we're not a public forum. And they need to be clear on that for everyone. Right? Because otherwise, they're in this issue. So we'll see what happens. I bet that case is going to be around in the next 5 years. The League of Women Voters registers voters at Safeway.
I don't know, but
Oh.
that would be a great idea.
It would be a great idea.
Yeah.
It seems to me I read some time ago where public property, where forums could take place, people could demonstrate and all that, are gradually shrinking in this country, and privatization of these is increasing. It sounds like over the long run, we have fewer places we can express our First Amendment rights,
Yeah.
even though we have plenty right now, if that's the trend.
Yeah, so just to reiterate so everyone heard, it seems like there's a trend toward more private spaces and less public spaces. So if we don't have First Amendment rights in private spaces, then effectively we're losing our First Amendment rights as more spaces transition to being private from being public. Yeah, and that's the risk of the state actor doctrine as it currently exists. Yeah. So I'm going to need to move us along. I'm really sorry. I want to make sure we end on time, so if you have questions I didn't get to, please stick around afterward, and I'd be happy to stay as long as needed to answer questions. But we need to talk about the framework for analyzing rights, because this is really key, because not everything that the government does, or not everything that a state actor does, is a violation of somebody's rights. So the courts responded to this Lochner-era liberty of contract idea by saying, whoa, we are just the judicial branch of government, we're undemocratic, we shouldn't be making up what people's rights are, right? Let's let one of the more democratic branches of government expand rights protections through passing legislative acts at the state or federal level. Let's not be interpreting the due process clause of the 14th Amendment, I think the 5th Amendment, sorry, I forgot my copy of the Constitution, in order to expand what we think substantive due process means. So the court implemented judicial deference to government economic regulations. In other words, if the legislature passes a law like a minimum wage law, the court's going to say, well, does that law violate due process? Like this idea of life, liberty, or property. Because it does affect people's property, maybe their liberty, if we still accept the liberty of contract theory, which some people do. But the court's going to be very deferential to the government. In other words, the government's law is probably going to be found constitutional. Meaning, the court is probably going to find the government's law constitutional. And what the courts do is they apply what they call a rational basis review. So rational basis review is basically asking the question, is the law rationally related to a legitimate government justification? And in constitutional law language, we say this is a ends means test. So the end is a legitimate government purpose or justification or intent or goal. Is it legitimate? And then is it rationally related? So minimum wage law, the government says, well, we think it's important that people have enough income to be able to live on and meet their own needs. And the courts will say, yeah, that's a legitimate government purpose. That's about protecting people's health, safety, and welfare. And yeah, that's legitimate. And then, well, is setting a minimum wage rationally related to that? The court's probably going to say, well, yeah. I mean, if you let people work for peanuts, then they're not going to have enough to meet their ends. So setting a minimum wage helps to get there. It's rationally related. This is a very easy test to pass, right? And the courts defer to the government. The government can make up its reason for why it did something afterward. It's very deferential. The rational basis review is all in the government's favor. So if someone comes in the court and says, we want to challenge this law, the first question the court asks is, well, do we apply rational basis review, or do we apply a harder test to decide whether the government's law is constitutional? If it's rational basis review, it's more likely than not going to be constitutional. Like, it's a pretty easy test to pass. But what the courts say is that when there's a fundamental right at issue, or when a law affects a discrete and insular minority, the court's going to take a very careful look at the law. Now, the government is not going to get any deference. The government's going to have to prove that it's not violating people's rights when somebody challenges a law that affects something like race, something like gender, that's more intermediate, something concerning people's ethnicity, right? So the courts have this strict scrutiny analysis, meaning that it's not just, is the government's action rationally related to a legitimate end, but rather, is the government's action compelling, did I get that right? Compelling interest to justify a necessary end. So let's break it down. So the first question, you want to come into court, what was the example? Love Canal, right? So toxic sludge, toxic chemicals harming people. The government sanctions it and says, yeah, this is legal for this to happen. I forget the exact details of Love Canal, but let's assume that there's state action, just so we get past that threshold. Then somebody comes into court and says, this action of the government violated our fundamental right, our due process right to life by poisoning us. The court's going to say, well, our first question is this a fundamental right? Is this something that is part of life, liberty, and property, which the government cannot take away without due process of law? Is it a fundamental right? And that's the threshold, a threshold question. If there's no fundamental right, well, then we're going to go to we're probably going to go to rational basis review, and the government just has to say that there was a legitimate government interest and it was rationally related, right? So the plaintiffs in that Love Canal hypothetical are going to have to then show rational basis doesn't apply. But if it is a fundamental right, then they get this higher standard, this strict scrutiny standard, or something between rational basis and strict scrutiny. We're doing a really quick version of this. And so the court then asks, well, is that fundamental right infringed, right? Just because you have a right doesn't mean that every time the government does something that your right is infringed. So this gets to the famous line from Justice Holmes, you can't yell fire in a crowded theater, right? So, you have a right to free speech, you can say fire, but Holmes says, but you can't do it in a crowded theater. Because that sort of action isn't protected. And the government's saying, well, no, like pulling the fire alarm, without it there actually being a fire. Well, that's not actually protected speech. It's not the best example. I should have pulled a different example. But the second question is the constitutional right infringed? So if the constitutional right is infringed, then the question is, well, actually, I'm really sorry that I messed it up. Is the constitutional right infringed? Yelling fire in a crowded theater, well, the government says you can't do that. That is infringing your right because you have the right to free speech, right? So we get past that. I'm really sorry about that. So then the question is there a sufficient justification, the ends, for the government's infringement of a right? In the fire in a crowded theater example, we say, well, people could stampede, people could get killed trying to leave the theater by a few exits. This was at the time when there were probably candles and it was more of a fire risk or whatever. So there's a potential loss of life by somebody doing that. So does the government have an interest in preventing people from getting stampeded, trying to flee a burning building? Probably. Probably that's a compelling interest, right? Love Canal. So poisoning people, if the court says, well, your right to life includes not being poisoned by the government. If they say that's a right to a fundamental right, then is the constitutional right infringed? Well, the government did something that caused people to be poisoned or being exposed to toxins, toxic trespass, that idea. Well, the court will probably say, yeah, that constitutional right was infringed. So then step 3, is there sufficient justification for the government's infringement of a right? And this is where the burden is now on the government. When we're at strict scrutiny, the government has to come up with that interest. It has to say, we have this compelling interest in ensuring that people aren't trampled when they exit the theater fleeing a fire, or that people aren't poisoned. See, I kind of like the idea of the right to life, including, prevention of chemical trespass, but I don't think the court does.
But you said in We the People 2.0, we don't have any rights.
Yeah, I don't think the court's going to go there, but I'm trying to follow your hypothetical in this analysis. So the question would be, is there a compelling government interest? Well, why would the government allow? Well, the government has to be able to allow industry to take place. And if people are free from any kind of chemical exposure, well then how do we have an industrial economy? We probably can't. So does the government have an interest in maintaining an economic system which we all theoretically benefit from? The court might say, yeah, that's a compelling interest, right? So there is a compelling government interest. And then the last step is the means sufficiently related to the purpose? So the court's going to say the government must show that the law is necessary to achieve the objective, that the government could not obtain the goal through any means less restrictive of the right. No other alternative less restrictive means can work. So, again, if you get strict scrutiny, the burden is on the government. But the courts very narrowly allow strict scrutiny. It's usually things like a law that facially discriminates on race, right? Like an affirmative action law. The courts say, hey, facial racial discrimination, meaning the law in its text says that it's choosing people or benefiting certain people on the basis of their race. So the court's going to apply strict scrutiny. And perhaps the irony of it is that the most effective plaintiffs using the Equal Protection Clause and winning in the strict scrutiny analysis are white college students trying to overturn, somebody started a timer for me, trying to overturn affirmative action laws in colleges. Right? So that strict scrutiny analysis is there. If you can get to it, the burden falls to the government to prove the constitutionality of the law. But most of the time, when somebody tries to use, like the 14th Amendment Due Process Clause, to challenge a law, the burden is on the challenger because you're in rational basis review. Right? So the big question for anyone litigating constitutional rights is, can we get that strict scrutiny and put the burden on the government to prove the constitutionality of its law? Or are we litigating under rational basis review, and thus it's our burden to show that the government has no legitimate reason for passing that law, and that the law is not rationally related to the purpose that the government claims that it's passing the law to do. So that's a challenge. I want to end with Korematsu as an example of this, because it's a really important case. Also, right now, the library has an exhibit on Japanese internment here in Port Angeles, and it's worth looking at. So head up to the library between 10 and 8 on most days. And it's this interpretation just in the main foyer area there, or inside the library. Korematsu versus United States. In World War II, the United States passed an executive order that said all people, Japanese ancestry, whether U.S. citizens or not, must report to certain areas, basically the internment camps for Japanese Americans. Korematsu didn't go. He violated the law. And the U.S. Supreme Court said that that law was legal, right? So the court applied strict scrutiny. Applied this, is there a fundamental right? Well, yeah, you've got a fundamental right to, live where you want, not have to, report to a detention center, But that the federal government had sufficient reason, had a compelling interest, and that the means were related. So what the majority of the court said is that it should be noted to begin with that all legal restrictions which curtail the civil rights of a single racial group are immediately suspect. Right? This was about one racial group, immediately suspect. The court's not going to just let the government slide on this. That is not to say that all such restrictions are unconstitutional. Right? So just because the right's infringed doesn't mean the right is violated. It is to say that courts must subject them to the most rigid scrutiny. So we now say strict scrutiny, but they said at the time in 1944, the most rigid scrutiny. Pressing public necessity may sometimes justify the existence of such restrictions. Racial antagonism never can. So if the government is doing this just to be antagonistic to a particular racial group, that's unconstitutional. But if there's pressing public necessity, then it's okay. Well, it might be okay. Sometimes justify the existence of such restrictions. We are unable to conclude that it was beyond the war power of Congress and the executive to exclude those of Japanese ancestry from the West Coast war area at the time they did. So in the Korematsu opinion, the U.S. Supreme Court said that Japanese internment in that way that Korematsu violated was a constitutional act. It passed strict scrutiny. It's one of the only examples where a law has passed strict scrutiny on the basis of facial racial discrimination. And it had a lot of dissents. A lot of justices dissented from that. I'm just going to read an excerpt from Justice Jackson's, which I put in the handout. He said, once a judicial opinion rationalizes a military order to show that it conforms to the Constitution, or rather rationalizes the Constitution to show that the Constitution sanctions such an order, the court for all time has validated the principle of racial discrimination in criminal procedure and of transplanting American citizens. The principle then lies about like a loaded weapon, ready for the hand of any authority that can bring forward a plausible claim of an urgent need. So this is lying around like a weapon, and it can be used by any authority that says there's an urgent need. So I'm going to end there. I'll be happy to take questions afterward. Thank you for coming. Same time, same place next week. Grab the handout in the back about